All right, so we'll start with Mr. O's client, Rosario. This is the people of the state of Michigan versus Luis Rosario. Case number 22F57203. Mr. Rosario is charged in count 1 with carjacking, count 2, controlled substance possession less than 25 grams, count 3, police officer assaulting, resisting, obstructing. He's placed on notice that he's a habitual offender 4. Is he in custody, Mr. O?
Yes, Judge. He's in custody in Isabella County.
May I have your appearances, please?
Good morning, Your Honor. Jaron Anderson on behalf of the people, P85434.
Thank you. Good morning.
Good morning, Judge. Neighborhood Defender Service by Glen O, PA3424, appearing on behalf of Mr. Rosario, who is not present. We're asking the court to consider waiving his presence for today's hearing.
Thank you. The court is going to waive Mr. Rosario's presence for today's probable cause conference. Today's the date and time set for a probable cause conference. Mr. O, have you received discovery?
Judge, we have received paper discovery. I requested digital discovery, and APA Blair Moody said he's reached out to the OIC twice now with no response.
Mr. Anderson?
Yes, that's correct, Judge. This case was recently transferred from another courtroom to Your Honor's courtroom. I have been in contact with APA Moody. He has not received an answer as to digital discovery from the officer in charge. However, I intend to also reach out and hopefully have an answer from Mr. O before this matter comes up again before the court.
All right, thank you. Let me look, because I hear that Mr. Rosario has another case that's scheduled before being.
On May 19th at 10 a.m., Judge.
Okay. All right, so why don't we schedule his second case for the same day, May 19th at 10 a.m.
Understood, Judge. That works for the fence.
Okay. All right, so then I don't have a writ yet. I don't see a writ.
Your Honor, if I may,
Yes.
I believe you actually signed a writ on the other matter, Your Honor,
Okay.
just yesterday, and I've gotten it over to the appropriate people.
All right, thank you. All right, so then we'll see you May 19th at 10 a.m.
All right. Thank you, Judge.
Thank you, Judge.
Ready on Zion Jackson.
Ready.
Mr. Jackson.
He should be in the waiting room. There he is.
Spoken to him, correct, Mr. Schwartz?
I'm sorry, say it again.
Have you spoken with Mr. Jackson?
Yes, I have. And I told him that we were just getting a new date so I could get discovery. And the fact that you're going to take both cases makes it much easier. I did put a request in for this case. I just got the appointment slip for the second, so I haven't put in the request for that one. So I'll need discovery on both.
Okay, thank you. This is the people of the state of Michigan versus Zion Jackson, case number 22F56078. Mr. Jackson is charged in count 1 with false report of a felony. Okay, hold on, I'm gonna call the second case. Also calling the people of the state of Michigan versus Zion Jackson, case number 22-0572340. Mr. Jackson is charged in count 1 with police officer fleeing 4th degree 3. May I have your appearances, please?
Good morning, Your Honor. Jared Anderson on behalf of the people, P85434.
Jeffrey Schwartz, P 32076. We agree to go forward by Zoom. Mr. Jackson, touch your screen and touch the camera so we can see you and say your name.
He's not connected to audio, so he's unable.
Okay, I'll call him and I'll work on that with him so he can come in better next time.
All right, thank you. The court will waive Mr. Jackson's presence for today's probable cause conference. The court will note that he is in the Zoom meeting, however, his audio is not connected. These matters are both set for probable cause conferences today. Mr. Schwartz, you have not received discovery, correct?
Correct.
The court will order that discovery be provided to the defense no later than a week from today, which is going to be May 13th.
Okay. Could the court, I don't know if it'll be too soon or not, but could the court set it for the 17th? I have a pretty open day that day.
These are your cases, Mr. Anderson.
One of these matters will be handled by APA Club. That would be the first one that was originally scheduled for this courtroom.
Okay. All right, so.
And you'll let that APO know to get me the discovery?
That's correct, sir. I'll also loop you in on an email that we got contact information for.
Okay, awesome.
So I'm gonna schedule these matters for exam on,
Oh, for exam or PCC?
for exam.
Oh, all right.
Um, I can do. I can do 9 o'clock on May 17th.
Okay, well, if it's gonna be an exam and we have to do it in person, can you put it later in the morning? Because I do have an AOI at 9. And if it's gonna be a waiver, I'll notify the court and we'll Zoom in. I mean, 10 or 11 should be fine.
Okay, I'll do it 11 o'clock.
Perfect. Thank you.
You're welcome. I'm not sure, your client is on camera, but I'm still not sure if he's connected. Oh, he is.
I've got his number. I'm gonna call him as soon as we hang up.
State your name, sir.
Can you guys hear me?
Oh, there he is. Okay.
Tell us your name.
My name is Zion Dean Jackson.
Okay, so Mr. Jackson, you'll have to come into 36th District Court on May 17th at 11 a.m.
And sir, if that changes, I'll let you know. I'll explain everything to you. We'll talk this weekend. And I'm sorry, the APA, can you give me the APA's name on the second case, please?
Yes, sir. That would be Jaron Anderson. First name Jaron, Jaron, last name Anderson, usual spelling.
Thank you.
All right,
And
thank
you-
you. You're all set.
Thank you.
Thank you, Judge.
You're welcome.
Okay, you're all set. I'll call you this weekend, Mr. Jackson. I know you need some information. I'll get it to you.
Okay, thank you. I appreciate you, Mr. Schwartz.
Yeah, it's okay. Bye-bye. Have a good weekend, everybody.
Ready, Ms. Spear?
Yep, I'm ready, Judge.
Okay. This is the people of the state of Michigan versus, is it Michael Leah Hope? Case number 22 F57176. Ms. Hope is charged in count 1 with failure to stop at the scene of an accident resulting in serious impairment or death. May I have your appearances, please?
Good morning, Your Honor. Jeremy Anderson on behalf of the people, P85434.
Good morning, Judge. Neighborhood Defender Service by Hannah Barron, P85265, representing Ms. Pope.
Thank you. Ms. Pope, if you can please, you can just stop walking and just say your name for us. Tell us your name.
I'm sorry, you said it.
Say your name.
Shayla Pope.
All right, thank you. Today's the date and time set for a probable cause conference. Ms. Barron, have you received discovery?
I have, Judge.
You'd like the court to schedule this for an exam?
Yes, please.
I can hear this on May 18th at 10 a.m.
That'd be fine for me, Judge.
Okay, so Ms. Pope, you'll have to come into 36th District Court on May 18th at 10 a.m.
Okay.
Is there anything further?
Nothing from the people, Judge. Thank you.
No, Judge, thank you.
All right, thank you. We'll see you then.
Thank you. You can log off, Ms. Pope.
Okay.
Ready on lock?
Just a moment, Judge. Can I see if my witness is here?
Sure.
Thanks. No witnesses, Your Honor.
This is the people of the state of Michigan versus Emmanuel, case number 21, F59804.
Apologies, Your Honor.
This is case number 21, F59804. Mr. Locke is charged in count 1 with weapons, strength concealed. May I have your appearances, please?
Good morning, Your Honor. Jeremy Anderson on behalf of the people, P85434.
Good morning, Your Honor. Neighborhood Defender Service by Emmanuel, P85234, on behalf of Emmanuel.
Thank you. Mr. Locke, state your name, sir.
Emmanuel,
Good morning.
good morning.
You can leave your mask on, sir. Today's the date and time set for a preliminary examination. Are the parties ready to proceed?
The people are not ready to proceed, Your Honor. We're missing necessary witnesses and we're unable to proceed in their absence. I'm unable to explain their absence in court today.
Ms. New?
And Your Honor, the defense is moving to dismiss at this time as we are ready to proceed.
Thank you. This matter was set for exam to occur at 9 o'clock this morning. It's now 9:15, and the necessary witnesses have failed to appear. Because of those witnesses' failure to appear, the court will grant your lawyer's motion dismissing the case against you. Please understand, Mr. Locke, that the dismissal is without prejudice, which means that the prosecution can reissue it if they're later able to locate the witness. But it is dismissed today, so that's it.
All right, thank you.
Thank you.
If there's anything else,
Are you ready, Mr. Gold? You ready?
Yes,
Okay. This is the people of the state of Michigan versus Ricardo Wafford, case number 22 F57212. Mr. Wafford is charged in count 1 with operating while intoxicated, third offense notice. Count 2 is a misdemeanor. He's placed on notice that he's a habitual offender before. And have your appearances, please.
Good morning, Your Honor. Jeremy Anderson on behalf of the people, P85434.
Good morning.
and good morning, Your Honor. Robert Gold, P14090, representing the defendant, Ricardo Cortez Wafford.
Thank you. Mr. Wafford, state your name, sir.
Ricardo Wafford here.
All right. Good morning, Mr. Wafer.
Good morning.
Today's the date and time set for a probable cause conference Mr. Gold, have you received discovery?
Have I, what?
Have you received discovery?
No.
So the court is going to order that discovery be provided to the defense no later than a week from today, which is May 13th.
If I
All
may,
right,
Your Honor.
So, but we are going to be holding an exam.
Okay, go ahead, Ms. Barrington.
Thank you, Judge. I did send discovery to the attorney of record on the register of actions, which is listed as the Linda Cameron, yesterday. However, I will get that discovery over to you via email, Mr. Gold.
He's gonna email the discovery to you.
Okay,
All right, so then I'm gonna schedule this for a preliminary examination. I can do it on May 18th. At May 18th at 10 a.m.
Can I have it pushed out a little further?
No. Why?
I just need time to, I wanted to hire another, lawyer. Get retainer fee.
When do you plan to do that? Who are you trying to hire?
I'm going to hire, I didn't get his first names, Mr. Warren. And I plan to hire him within the next 2 weeks.
What's his last name?
Huh?
What's his last name?
Mr. Warren?
Warren. Warren?
Yeah, Warren.
Oh. I don't know. McAlpine, Warren McAlpine, is that who you're talking about?
I'm not sure of the first name. He's I was a friend of the family had sent me a number to call him.
All right. All right. So what I'm gonna do is I'm gonna set this matter over for a PCC. I'll give you we'll set a PCC for May 18th at 8:30 a.m.
Okay, thank you.
So Mr. Gold, it's just gonna be a PCC on May 18th.
okay, and of course, Mr. Wafford, I gave you my phone number, and I hope you will let me know for sure, one way or the other, as to whether or not you're going to be able to get another attorney, or you will want me to represent you.
Yeah.
Fair enough?
So on May 18th, you all are gonna appear over Zoom again, okay?
Right.
All right. Thank you.
All right, and thank you. And I'll look forward to hearing from you sooner rather than later, Mr. Wafford.
Okay. Are we going to be same time? Are we going to be same time, same courtroom?
Yes, 8:30 on May 18th, yes.
Okay.
Okay, and you have my phone number, right?
Yes.
All right. So you'll let me know in advance for sure, one way or the other, right?
Yes, I will, Mr. God.
Okay, I appreciate it. Thank you.
All right, thanks.
All right. Bye-bye.
Morning, Judge. Good morning. How are you?
All right. How are you?
How are you?
I'm good.
Okay. Okay, that's what I was wondering. Okay.
No, there.
Darren,
No.
he's not here yet. They forgot to bring him. They forgot to bring him, so.
Good morning, Your Honor. How are you? Good, I'm like going, because they're like 4 exams this morning, evidence right here, so I'm like, I'm ready to go. All right. Now, 13 years. Nice.
You all right, Joe?
Yeah.
Hey, have you haven't had a chance to get out there?
Yeah, I played Sunday.
You did?
Played Sunday.
Oh,
First
wow.
round, 18 holes. I was hitting the ball, so I was happy, but they kept on.
But that's just just
A
gotta
little
get an
adjustment.
adjustment.
So I
That's
had
all.
a lesson on Wednesday. And he corrected me on Wednesday.
You know when you get back. Yeah.
Have you played?
No, I have not. I can't wait to get out there. I mean,
Next week is
that's where I'll be out there trying to see if I get my physical right, so I can touch it.
Wednesday, I figured.
So what do you think? When you bringing it back
I'm
and
not, but we have to do some drills
uh-huh.
that really like. Drills that really helps a lot.
if you say you slice it, so you hit it out of here.
Maybe
See, that's what it's.
but I can't process all that.
It's easy said. But if you bring it back, it's. And that's another thing. That's when you lose it. Right. Yes. Yeah. Oh, I think so. When you do this, let me know how that works. Because I see what he's doing. He's having you come here first and then bringing it out, then coming down, just to keep you focused on not bringing it back too fast. And that's another thing. You know, come down too fast. It don't take that much to get that ball.
I got my tempo. I had to get my tempo the last time. And don't go back too much.
Like a pendulum. Just do that. Now, you see some pros, they do that. Like, he brings, I don't know how he does it, but he knows how to
My
do
body
it.
can't
You know,
turn.
that torque, you be like, that's why his back was bothering him, because he was trying
I try to go Wafford and put me on a trespass list.
to put you in a chest fast. You gotta pay for it.
It's frustrating.
He's so good.
You guys are, let me know when you're ready on the item.
Right, Your Honor.
Okay. Okay.
Actually, I'm sorry, Judge. My officer in charge is in address. We would just want to call that CR. Thank you.
Good morning, how are you?
What is it?
You can move forward without the officer in charge.
This is people of the state of Michigan versus species Anissa Aedo. Case number 22F57083. Mr. Anissa Aedo is charged in count 1 with assault with intent to do great bodily harm, less than murder, or by strangulation. Count 2, weapons felony firearm. Count 3, assault with a dangerous weapon. Count 4, weapons felony firearm. He's placed on notice that he's a habitual offender second. And your appearance.
Good morning, Your Honor. Jaron Anderson on behalf of the people, PA 5434.
Jeffrey Edison on behalf of Quasi, he's A new P25912.
Thank you. Mr. Mesa Adu, can you please state your name for the record?
Quasi, Emisa Adu.
Good morning.
Good morning.
Today's the date and time set for preliminary examination of the parties ready to proceed.
Yes, sir.
The people are ready to proceed, Your Honor. We have all necessary witnesses.
Are there any preliminary matters?
Nothing from the people, Judge.
No.
Okay. Court will order all witnesses sequestered. There will be an exception for the officer in charge. Mr. Anderson, how many witnesses do you have?
Just one, Your Honor.
You call your first witness.
People we call Denzel Rogers.
Mr. Rogers, come on in, sir, and provide the spelling of your name to the court. Sir, can you raise your right hand? Do you swear or affirm that the testimony you'll provide will be the truth? Okay. Is that, let me have one. Okay. You can take that off. You can have a seat in the black chair. Here's a microphone that's right next to you. Grab the base of the microphone and pick up the entire base of the microphone. Make sure that the red light is on. We need you to hold that and speak loudly and clearly into the microphone. Press the button.
Hello.
Thank you. All right, your witness, Mr. Anderson.
Thank you, Judge.
Welcome.
Can you restate your name for the record, sir?
Denzel Rogers.
Mr. Rogers, I want to take you back to the date of April 19th, 2022. Do you remember that day?
Yes.
On that day, were you at or near the location of 15559 Normandy Street?
Yes.
City of Detroit, County of Wayne?
Yes.
What is that location, sir?
That's the location of the Quasi house.
And Quasi, do you see that individual in court today?
Yes.
Can you point to that individual and identify an article of clothing that they're wearing?
In the green jumpsuit.
Your Honor, may the record reflect the identification of the defendant by the witness?
The record is already done.
So why were you at that location, sir?
I actually came to ask him on my phone, turn my phone off.
Did something happen at that location that brings you to court today?
We got into a scuffle and then I busted his window off and then he tried to shoot at me.
Okay, let's break that up just a little bit. So when you first got to the location, what happened?
When I first got there, I knocked on the door. He actually went to the side door. And I said, he asked me what I wanted. And I said, why don't you turn my phone off? That's where you went back and forth, got discussing and stuff. He put me on the garbage can and I tried to like throw it at him, but I couldn't.
Okay, so after you said he flipped you on the garbage cans?
I like to push me.
Hold on, okay, I gotta stop you. You have to wait until after he's completely asked the question.
Okay.
Two people can't speak at the same time because she's recording everything, okay?
Okay, no problem.
Thank you.
Thanks, sir. So I'm gonna ask the question again. What did you do with the garbage can, sir?
The garbage can was behind me. I just got pushed into it. He pushed me.
And who pushed you in the garbage can?
Pushed me.
So after he pushed you into the garbage can, what happened next?
I got mad and well,
What happens next, sir?
after that, he like stepped up to me, but I thought like I asked him what he was gonna do. I just repeated answer that, and then we discussed him this and that. He went back in the house, which is well, I can walk away. To my
Okay, so
house.
after he went into the house, what happened next?
About like 2 or 3 minutes later, he came out with a gun.
Who came out with the gun, sir?
But
How do you know he came out with a gun?
he popped 2 rounds off in the air.
When he came out with a gun, did he say anything to you?
I don't remember what he said, but he probably said something. I heard something from his mouth.
All right, sustain.
Sir, do you remember his exact words or no?
No, sir, he was shooting. I wasn't trying to hear what he was trying to say.
Okay. So, you say you shot 2 rounds up in the air. Can you explain what you mean by that?
As I walked away, he was by his post by his house, shooting. And
Where were you when he was shooting, sir?
I'm in the middle of the street, walking pretty fast, slowly. I mean, not running, but I was walking towards my house. When I got to my work, like my first step, that's when he was done. But he popped like all 5 rounds all together.
Do you know, could you see him when he was?
Oh, look at that. I was
You're
talking.
still talking as he's asking the question. You have to wait until after he's asking the question.
Sorry, sir, I'm asking the question again.
Yes, sir.
Did you see the defendant when he was shooting?
Yes, sir.
And what did you see, when you observed the defendant shooting?
He had his gun. He was shooting towards me at my house.
Can you tell where the gun was pointed?
Yeah, that's where I am.
And how many shots?
5.
Did you hear? 5? Thank you. Did any of those bullets hit you?
No.
Did any of those bullets hit your house?
Yes, I seen dust on my left post.
Okay.
And one went past my ear.
And where were you again when the defendant was firing the shots?
First I was in the street, and then when I got to the sidewalk, he popped his 3rd round. When I got to the left, when I first post, it was the last like 2. It was over with.
Okay. Thank you, sir.
No
Thank you
problem.
for your honor.
Cross-examination, Mr. Evans.
Mr. Rogers, I'm going to ask you some questions. If you do not understand my question, will you let me know?
No problem.
All right. Now, you know Mr. A2 for over 2 years, is that right?
Nope.
How long have you known him?
Year and a half.
And during that year and a half, did you know him by living on Norman?
Yes. And no.
You also live on Norman.
Yes.
Your house where you live is across the street from Mr. Avery, is that right?
Yes.
And it's about 4 lots down from him, going towards the expressway, is that right?
Lots, no. This
No,
house.
lots, not lots, lots.
So my driveway.
All right, there's about 4 or 5 driveways.
About 4 or 5 is my house. Yeah, it's good. It's not real long.
So your house is about 5 houses down from his house. Is that right?
Yeah.
And across the street.
Across the street.
Earlier this year, you were having problems with your phone.
Objection, Your Honor, relevance.
It's material to what you said. He went to the house about the phone.
Allow.
You were having problems with your phone, is that right?
Not earlier this year.
Well, when did you begin having problems with your phone?
About a month ago.
And Mr. Adu helped you with that problem. Is that right?
Yes.
In fact, Mr. Adu said he would pay.
Objection, Your Honor, hearsay. He's offering these defendants on state.
All right, your response, Mr. Harrison.
It goes to the essence of what the dispute is all about.
All right. It's still here saying.
All right. You had problems that Mr. Adu was helping you with maintaining your phone. Is that right?
You say,
Your phone was cut off. Is that right? For lack of payment.
nope, it wasn't put off. He paid it, then he proceeded to cut it off more. My mother told me not to do that.
Let's listen to my question.
I answered it.
I said, listen, witness, to my question, please. Your phone was cut off for lack of payment.
Nope, it was not.
You have an agreement to pay Mr. Adu for paying on your phone.
Yes,
The phone was cut off and you asked Mr. Adu about it. Is that right?
that morning, yes.
Mr. Adu, before this day, had agreed to continue paying on your phone if you would pay it back later. Is that right?
He did say that. But he was told by my
Now,
mother,
listen to my question. That was the agreement you had with Mr. Adu, right?
yeah. He took it
You
upon
did
himself
No,
to
so
do that.
listen, sir, he's not asking you a question. So please just wait until the question is asked. You understand? You have to answer with words.
Yes,
You did not pay Mr. Adu back, and the phone was cut off again. Is that right?
Objection, Your Honor, asked and answered, and I would also object to the relevance.
All right, I'll allow it. On the day of April 19th, have you paid Mr. Adu for your phone?
no, I did not.
The phone was cut off, and that's what you came to Mr. Adu's house to confront him about. Is that right?
Yes,
So you leave your home, 5 houses down the street. You come to Mr. Adu's house and knock on the side door.
nope, front.
Mr. Adu comes to the front door. Is that right?
No, he came out the side.
And when he came out the side, did you then leave the front and go around to the side?
Yes, I did. He told me to come around.
Did you then confront him about why he had stopped paying on the phone?
No, not stop payment.
What did you ask him?
I asked him why the phone was continuing to be off when I had to go to work. Now he was going to be paid Friday. We already had an agreement. We had an agreement. But it would be paid, like you said, right?
And the agreement broke down, right? And you were mad about that, right?
Somehow, yes.
Somehow.
Somehow it got turned off and he didn't say anything to me about it.
All right.
It was agreement to be paid on Friday.
But you were mad with Mr. Adu. Is that right?
I was upset, yes, I was.
And that's why you went down.
Yes, I was.
And you are a younger man than Mr. Adu, right?
Yeah.
You consider him to be an older guy. Is that right?
Of course.
And you got physical with him.
No, he got this with me.
He pushed you.
Yeah,
Were you close enough for him to reach out to you?
he walked up on me.
Had you said any threatening words to him?
Oh, yeah, we did.
What did
We exchanged words.
What kind of words did you say to Mr. Adu threatening you?
Well, he said, you ain't gonna lose.
No. What threatening words did you say to Mr. Adu?
I said, I'm gonna bust your window out.
You
That's
also
exactly
said,
what I did.
you also said you was gonna kick his ass.
Nope,
You didn't threaten him physically.
nope.
So you told him you were gonna bust his window out,
Yes,
right?
I did.
And why were you gonna bust his window?
Because I told him that He was gonna be paid Friday. He continued to play, I guess, a game with the phone. He turned it off, and then he put his hands on me.
And when he put his hands on you, you didn't get physical back with
I
him?
could have, but I'll be sitting just like that with him. No, I'm not gonna do that.
So you figured you just break his window out?
Oh, yeah.
You say you broke his window out now, but when the police came that day, you told the police you never did break his window out, did you?
I did say that.
And why did you tell the police that?
I lied. I did.
You lied?
Yeah. They caught me on camera. And
Yeah.
they gave me a ticket.
Okay. And so you pick and choose when it is you're gonna lie and when it is you're gonna tell the truth.
Objection, Your Honor, argumentative.
You pick and choose when you're gonna lie and when you're not gonna lie. Is that right?
Nope.
Well, you did that day.
Yeah, right there.
Pardon?
Yeah, right there.
What do you mean right there?
Yeah, right there, but you can't overgeneralize that.
What
did you say?
Overgeneralize, that means you can't put that in everything I do. You can't say, oh, you're gonna do that every time.
Yeah, the point is that you're the person that decides when you will specifically lie or not lie.
They said no.
But that day you decided to lie to the police when they
Yes.
came. Is that right?
That's right.
All right. So when you break the window out, you continue to scuffle with Mr. Adu. Is that right?
Nope, never said so.
Well, when you first were asked questions by the prosecutor, didn't you say that we scuffled?
Nope,
You didn't say that
I
earlier?
didn't say we stumbled. I said that we got into it with words. He walked up to me and I backed up on camera.
Do you recall testifying about 15 minutes ago that you described the interaction as we scuffled?
Okay. No,
If I told you that you testified we scuffled, would that refresh your memory as to what happened?
no. No, what happened? I don't know that, that's my memory.
Well, you do know that after you broke out Mr. Adu's window, you ran down the street to go home.
Nope, you're not right.
How did you go back down the street?
Walk peacefully.
And you were about 5 houses, you were in front of your house when you saw Mr. Adu come back outside?
Mm-hmm.
No?
No,
You weren't in front of your house?
no,
Where were you?
in the street,
In front of your house?
no, in front of his driveway.
In front of his driveway?
Yeah,
And it's in front of his driveway, when you say he fired 2 shots in the air?
yep. As I hit the second block,
Listen. How far from Mr. Adu were you in front of his house when you say he fired shots up in the air?
I was in the street when he fired 2 shots in the air, in the middle of the street.
My question is, how far were you?
I don't know how far it is. If I'm in the middle of the street and his house is right there, what do you think, sir?
You have to witness, it's not your position to ask questions. You just have to answer the question that I put, all right?
I answered it.
Do you know how far you were from him?
Objection, Your Honor, asked and answered.
I'll allow it.
Do you know how far you were from him?
Yes,
How
in the
far?
street,
You don't know this.
a half a block, a half a house away. You can put a house right there in front of it if you wanted to.
Okay. So you're about a house away from Mr. Adu when he fired shots in the air.
Yep.
And you just watched him do that, right?
Mm-hmm.
Right, yes.
Around.
Is that it?
Yes, I turned around.
That didn't frighten you, did it?
No,
Cause you knew that because of your relationship with Mr. Adu, he wasn't gonna shoot you. You
Nope.
knew that, right?
Did not know that. Never thought he would ever shoot,
But-
or ever put a gun at me, ever.
But it didn't frighten you.
No, guns don't frighten me, sir.
Alright. So you're a house away. You got 4 more houses to go to get to your house. Is that right?
One,
Didn't you say earlier that your house was about 5 houses down from Mr. Adu?
if I think about it, it is about 3 or 4, but not exactly 5, but yeah.
So after he fired 2 shots in the air, you were just 1 house away, right?
Yeah, I was
Then,
on the sidewalk at that point.
then you had to get to your house before the other shots were fired, right?
As I walked to my house, the other shots were fired. The last shots were fired. When I took my first step on my first step on my steps to my house. That was the last shot that I heard.
I just want you to listen.
Answer your question.
So,
All right, so sir, you're being rude. You need to answer the questions that are asked of you. Do you understand?
Yeah,
We don't need your commentary. Do you understand that, sir?
I understand.
after the shots were fired in the air, you say you just walked to your house?
Yeah,
And while you were walking to the house, to your house, your back was to Mr. Adu. Is that right?
yes,
And as your back was to Mr. Adu, you heard 4 shots.
yes,
Is that right? When your back was to Mr. Adu and you heard those other shots, you don't know if he was shooting in the air at that point because you weren't watching. Is that right?
I looked back my time to make sure I was all right. My back was still turned.
And as you were walking, you saw his hand up in the air, right?
But I was in the street, his hand was in the air.
And that's when you were hearing these other shots, right?
No, I was in the street when I heard the first 2. When I got to the sidewalk close to my house, in my neighbor's house, I heard the other 3. One
Was
went past my ear,
your
sir.
back still to Mr. Adu then?
Yes, sir.
Were you at your house there?
The last shot, yes. My last step on my porch, yes, I was.
Were you, but you weren't watching Mr. Adu fire that
I
fast.
was watching him do everything. My back was still turned up. My drill.
Did you know that the police examined the exterior of your house?
Oh,
Did you know?
no, no.
Did you know that there was no fire damage? Do you know that there was no damage to your house?
Objection, Your Honor. Yes, personal knowledge.
Did he know?
I think that. Was there any damage to your house?
I already had damage to my house. I don't think there was. It was just the bullets going everywhere. He doesn't know how to aim.
You said he doesn't know how to aim?
No, he could have hit me if I was on the street. I guess he just did it out of anger. I don't know why he would do something like that. I had no pistol or knife.
Thank you, sir. I have no questions.
Redirect.
Yes, Your Honor, thank you. Without telling me any words that you said or anything anybody else said, did you speak to the police on that day?
Yes, sir.
And when you spoke to the police, did you speak, was it the only time you spoke to the police about this matter?
Yes.
Did the police take a statement from you at any time?
Yes, they were handling the situation at the same time too.
How did the police take a statement from you?
When the police came, they went to his driveway, and they seen that I was outside, and then with an actual car, they came to me, told them my story right then and there. So they had the pistol in the house, and they they just stopped they stopped talking to me for a minute. They went exactly to his house. Okay. And the female came and talked to me after they, situated it, everything safe. You know what I'm saying?
So, I'm sorry, sir, let me interrupt you.
No, you're fine.
Did you ever at any point tell the officers that you had busted out the windows of Mr. Quessy's home?
No, I didn't go.
When you made other statements to police officers, did you ever? May I rephrase your honor? Was it the only time on that day that you had spoken to officers, or had you spoken to them on another day as well?
Another day, a detective called me back and I told him that I busted the law.
So on that day, you told the detective that you had busted out the windows?
No, the detective did not call me the same day.
This was the next day, I'm saying?
Yes.
Okay. Is that the truth, what you told him, sir?
Yes, sir.
So let's go back to after you hear the first shots. Where were you standing again, sir?
I was in the streets, with the first two shots.
And when you're inside the street, where were you looking when you heard those shots?
I looked back at him.
And when you look back, what could you see?
I could see him pointing in the air.
And what was he pointing in the air, sir?
A gun.
And then the other shots that you heard, where were you when you heard those?
As I'm walking to my house, I passed my first neighbor's house, my second neighbor, and then he was just like the first, like the third shot, second, and then I got to my porch, it was the last one.
Okay. So when you hear those shots, what did you do?
He kept looking back. I was like, and I was yelling at him like, "Are you shooting at me? Did this and that?"
Okay, sir. So when you're looking back, did you see anything?
I could see him shooting at me.
You can see him shooting.
Or shooting, the gun, for sure.
Where was that firearm pointed, sir?
At me, in my house.
And
the
bullets. I'm sorry, sir. I've got a question for you. So, the bullets that would have came out of that gun, do you know where any of those hit?
No, not exactly the one with past my ear.
How do you know one passed your ear, sir?
I heard it. I felt that. You can hear when it comes through. It'll go past your ear.
Have you heard that noise before? You
Yes,
know
sir.
that, sir? Thank you. Nothing further, Your Honor.
Mr. Rogers, I have a couple of questions.
Yes, ma'am.
You said you busted out a window. What window did you bust out?
It was the first window by the door.
At his house?
Yes.
Okay, so you're mad because he won't pay your bill?
No, I was mad after he put his hand on me, pushing me.
You came down there because you were mad because he wouldn't pay your bill?
No, they wouldn't turn the phone on so I can pay him. I had to go to work. You can turn the phone on and off. And I had to call my ride. We knew that. It was like, well, I want my money right now. I didn't have any money. My mom told him just leave the phone off until he paid. But he wanted to pay it and then hold it in front of my head. The thing play around every time. They just going off every day. I'm calling my mom. I couldn't call her. Come to the next day for work.
So this is your phone, right?
Yeah.
It's your responsibility, right?
Yeah.
And you mad at him because he wouldn't pay for it?
Not he didn't pay for it. He paid it and he told him not to. I knew I didn't have the money yet. I had to pay my DTE bill. I couldn't have no like gas. My DTE was $600.
All right, so your
I only make $400.
so your house is across the street from Mr. Quacy. And down, crossing down, correct? And at some point, you're walking on the sidewalk that's on the side of the street that you live on? All right, are there any questions based on the court's questions?
No, Your Honor.
No, Your Honor.
Okay, I'll send it to her. Yeah. No, just leave it as it is. Very good. Are there any other witnesses on behalf of the people?
Nothing from the people, Judge.
Any witnesses on behalf of
No, Your Honor.
Mr. Anderson?
Yes, Your Honor. Thank you. The people moved for a bind over on all counts. The testimony, Mr. Rogers has been that he went to a location to speak with somebody that he knew, that individual he identified to be the defendant. He went there to speak to him about a phone bill. During that encounter, he testified that the defendant turned what was normally a verbal altercation into a physical one by pushing into a trash can, I believe was the testimony. Later on, words were continually exchanged. The victim testified that he busted out the defendant's window but that's only damage to property. Never testified to threatening the defendant, using force against the defendant. He testified that after he had done this, the defendant approached him again. He then left the location. Any altercation between the defendant and the victim ceased at that point. He then saw the defendant go inside of the defendant's home, come back outside, and while the victim was in the street, he heard the defendant fire 2 shots in the air. Mr. Rogers knows this because he saw the defendant with the gun in his hand, point that gun in the air, he heard those 2 shots. He then victim continued walking to his home, and he then heard further shots from the defendant's location. When he heard those shots, he turned around and he could see the defendant holding the firearm, pointing that firearm at him. He also testified that some of those bullets went past his head. He even stated at one point that he believed one of them hit his home. So the weapon was certainly pointed at the victim. Those facts, Your Honor, show that the defendant's intent was at minimum to do great bodily harm upon the victim. With regard to any sort of self-defense claimed by the defendant, anytime we have assault cases, it's the prosecution's burden to show that the defendant was not acting in self-defense. In this case, we had a verbal altercation that was turned physical by the defendant, who was the initial aggressor. Further, the victim had retreated from that location. The defendant then turned a verbal altercation that he turned physical into a deadly one by having a weapon. And at that point, the victim was trying to leave the location to cease any sort of altercation that was occurring. So, Your Honor, for those reasons, people believe it matter burden of probable cause, move this court to bind over on our promise.
Your Honor, on behalf of Mr. Adu, we object to the bind over on these counts. And as the court at this time as the reviewing magistrate, under the Supreme Court decision of People versus Anderson, this court has an obligation to assess and evaluate issues of credibility and reliability of the evidence that's being presented. It is critical in assessing what happened this day to determine the credibility of this witness. Not only what the witness says, but the manner in which it is said, and the witness's demeanor from the witness stand. Most significantly about this witness testimony is his arrogance and admission to lying to the police during the initial investigation. He acknowledges that he lied to the police about what happened in terms of his own conduct and responsibility of being at Mr. Adu's house. And then on his own tries to minimize the significance of the lie by offering to this court that his lie is something that cannot be overgeneralized. That, in other words, just because I lied now, or because I lied then, doesn't mean that I always lie. But it's important because a lie is a lie. And he clearly lies when it is opportune for him to do so. Of course, my recollection of his initial testimony may not be accurate, but it is my recollection that on the prosecutor's direct examination, the witness started out the scenario by saying, "We scuffled at the side of the house," and that's when he busted the window out. Then, of course, he backs up and says that he didn't say scuffle, that he never put his hands on Mr. Adu. But notwithstanding the physical contact at the side of the house, but notwithstanding the breaking out of the window, it clearly is that Mr. Rogers is upset because Mr. Adu was tired of, if you will, nursing this young man by assuming his responsibility for paying the phone bill. Mr. Adu stopped paying the bill. It is Mr. Rogers' phone. Mr. Rogers gets mad and he goes to confront him. Now, what happens as a result of that? One, and certainly the prosecutor may say that Mr. Adu overly reacted, that he, whether or not he felt threatened, that threat from Mr. Rogers was not significant enough for him to pull a weapon. Well, we do know that, or I guess from these circumstances, we can say that a weapon was fired. Mr. Rogers said that the weapon is shot up in the air. He's watching. He's not afraid. He's just walking back to his house that is 4 to 5 houses down the street and across the street. But when Mr. Adu first discharges the weapon, he's about 1 house away into the middle of the street. Mr. Adu fires up in the air, and then he walks to his house with his back to Mr. Adu after Mr. Adu has fired at least 2 shots in the air. Then he says, well, by the time he gets to his house, as he's walking, he seems to be turning back to look back at Mr. Adu, who then is still firing the weapon a few more times. Then he says how, well, it passed me by and perhaps it hit his house or something to that effect. And so it is our position that when this admitted liar offers a description of what happened, where he lies about minimizing his own responsibility, then he certainly is at least reasonable to conclude under these circumstances that he is lying about the culpability of Mr. Adu. And if it is accepted that a weapon was fired, then it is our position that it is reasonable to find that the weapon was fired in the air. And if that is not is not, or if that is in violation of any law, then it would be unlawful discharge of a firearm in public. Thank you.
Mr. Anderson.
Yes, Judge, thank you. I want to touch on credibility first. The witness testified that he initially did not tell the officers that he busted out the defendant's window. He testified that after speaking with the detective, he admitted to doing that. That not only shows that his initial lack of being forthcoming with the officers, sort of sat with him for a while, but then he wanted to right or wrong. He came here today, he went under oath, and he has testified to these facts under oath. Your Honor, I think everybody in this world has lied before. Get overruled by an officer, especially a police officer. Are you likely to tell them exactly how fast you were speeding, or are you going to jump that number down a couple times? Just because you don't give all the facts initially doesn't mean everything you say thereafter is a lie. Again, Your Honor, I think based on the witness's testimony, he's been rather consistent. He was truthful in telling this court, when answering defense counsel's questions, that he did not initially tell the officers that. He lied about that and told the court that he did tell them. Who would be here to say that he was lying? With regard to the relationship between the parties, I believe defense counsel was saying that the defendant was nursing this victim. He was frustrated by that fact. When we have responsibilities, special responsibilities that we take on ourselves, we don't evade them by attempting to shoot that individual who we owe those responsibilities to. Evading those responsibilities through heinous assaultive actions does not, it's not something that society would deem reasonable. It's not what the law deems reasonable. It's not a justification for using physical deadly force against an individual. Just because the defendant didn't hit him with those bullets does not mean that his intent was not for those bullets to strike the victim with that trigger. The victim testified that he saw the defendant with the firearm. That firearm was pointed at him, and that those bullets even went by his head. I believe potentially struck his home or post, I believe he said. Just because the defendant's a bad shot doesn't mean that he gets away with the charges that the people have brought against him. So, Your Honor, again, we believe we've met our burden with probable cause and move this court to find over all counts.
Thank you. The court heard the testimony from Giselle Rogers, who testified that on April 19th of this year, he went to 1559 Northern Street in the city of Detroit. He described that address as being Quasi's house. He identified the defendant, Mr. Ayedu, as Quasi. He said that they got into a scuffle, that he then broke out the defendant's window, and that the defendant came out with a gun and shot twice in the air. He said that the defendant had the gun and was shooting towards his house as he was walking down the street. He heard approximately 5 shots, and one of the shots went past his ear. He testified that his house is across the street and down from where the defendant resides. The court had an opportunity, the defendant is charged in count 1 and count 3. 1 with assault with intent to great bodily harm, less than murder. Count 3, assault with a dangerous weapon. The court had an opportunity to observe Mr. Rogers as he testified, to listen to him, and to watch him as he changed his testimony, I think, to benefit the person that was asking the question, or to exaggerate some of what possibly occurred on that day. And based upon how he presented in this court, I don't believe anything that he said. I would need somebody else to tell me that somebody was in the street firing him. And I would need somebody else to come in here and tell this court that there were shell casings that were found in the street. I would need to be out there. Just him alone, I would need to be out there to see it happening, because I don't believe him. He is dishonest. His whole thought process and reasoning is disturbed. And the way that he sat in his courtroom and answered questions that were asked of him by the defense attorney suggests to me that he would change his answers just so that he could make someone look a certain way. So without something further to suggest that something happened, I don't believe that the complainant witness in the case is dismissed.
Thank you. Follow me, sir. Judge, the county cell West should be here for this 30 minutes.
It's a later.
Secretary?
True, fair to say.
It is true.
And the doctor didn't order you to be off work for 8 to 10 weeks after you saw the doctor on the 27th. Is that fair to say?
He said I would have to heal to go back to work.
Is it fair to say that the doctor gave you information that you would be off work to be off for 3 days after this, after you left, at the time that you were discharged, excuse me, on September 27th?
3 days? That's what you said, sir?
Yes.
I'm not sure about that, no, sir.
So you were given discharge papers when you were released from the hospital on 9/27, correct?
That's correct.
Okay, and if I showed you those discharge papers, would remind you of the amount of time that the doctor said you would be quote unquote off work after you released from the hospital?
Nancy,
I just need an answer to that question and we can move to the next step.
could you state it again?
So if I were to show you the discharge papers that you received when you were released from the hospital on September 27th, would that remind you of the amount of time that the doctor ordered you to, if I can say it this way, take it easy?
No, that wouldn't remind me because it depended on how well my bones heal.
So if you were seeing the statement, wouldn't, excuse me, wouldn't tell you the information that you were given by the hospital at the time that you were released?
It's been almost 2 years, sir. I'm sorry.
Got a question with this with the discharge doctor. Discharge doctor.
All right. Are you saying that looking at those documents would not refresh your memory as to how long you were supposed to be off healing?
Correct.
All right. What would be the purpose in showing?
No, we can go a different way. That's fine. But it is fair to say that you were given discharge documents when you were released from the hospital in September, right?
Yes.
Or would you recognize those documents if you saw them?
No, I'm sorry.
I'm sorry, say that again?
I guess so. I'm not sure if I would recognize the paperwork or not.
Judge, can I ask for a student
All right. So for what purpose?
to see if she recognized the discharge documents that she was given on the 27th?
All right. So if she recognizes them, then what beyond that, then what's the purpose?
Okay, perfect. So I don't have to give away
Yes.
my question. That was it.
Yes.
Beach Water? Yeah, yes, sir.
Yes, sir.
Sir? Ready?
Yes, sir.
So fair to say you went to Sinai Grace Emergency Department on 27th?
26.
Or you were, excuse me, you were 26. You discharged on 27th,
Yes, sir.
8:05 a.m.
I'm not sure.
So you don't recall exactly the time you were released?
You said 8:05, but I remember being there until 11.
So the doctor said 8:05, you don't recall that doctor said 8:05?
I'm not objecting, I think Mr. Secretary is still trying to review my correct.
I don't have any medical records.
The
So,
papers that you have are.
I thought you were, are you finished with your picture?
All right, so they are, okay, so, sustained. And, Mr. Silver, please.
Okay, so you don't recall the document saying that you were released at 8:05?
Is the objection was sustained? The objection was sustained, so please move on.
I need clarity on the objection. She said something about medical records. I don't have.
So, Mr. Sinclair, the question that was asked by you before is sustaining the objection. The document that you have, you know, that is a medical record, part of medical records, the discharge papers from the hospital are part of medical records.
So what was the, my question was, can you clarify the scope of the objection?
All right, so I've ruled, so please move on.
I'm asking, what's the scope of
So
what the objection?
the question that you're asking about the time in which she was discharged, please move on.
Were you given work limitations at the time that you were discharged from hospital? Limitations or restrictions or anything like that?
Okay, the court is going, okay, so we've already had testimony from the witness that she was told to take it easy and allow her body to heal for a period of time that she believed to be 8 to 10 weeks. So we ask you to move on.
So that doesn't provide an answer to my question as to whether she was given work restrictions.
Ma'am, were you given work restrictions?
Now, it's been so long that I really just, I believe I was on work restrictions because I was on crutches and I had a hard time driving and anything accordingly.
So is it fair to say because it's been such a long time, you don't remember?
It is fair to say that I remember the 8 to 10 weeks.
Okay, so the question was about restriction. So I'm asking you, is it fair to say that because it's been such a long time, but since you were there, that you don't remember where you were given work restrictions?
I remember,
I'm sorry?
I remember 8 to 10 weeks, sir. That's what I was saying.
8 to 10 weeks, what was the?
It was 8 to 10 weeks for my healing. The doctor told me that I was going to have to heal. It was going to take some time. It would take up to 8 to 10 weeks.
And so you stay out for 8 to 10 weeks?
I don't recall him telling me to stay off of work for 8 to 10 weeks. He told me my body was going to have to heal and that I wasn't going to be able to do much because it was like my bones were broken because of the tissue damage.
Wait, I understand the last part of the question. You said the, no,
Because of the tissue damage.
All right, so after you got out of the basement, there's sometimes you tell the officer that you jumped out of the window?
Yes,
So which window did you jump out of?
the one behind the stove in the kitchen.
So that's not in the basement, right?
No, that's when I broke out of the basement.
Okay. Why'd you jump out of the window?
When did I jump out?
I
of the
said,
window?
why did you jump out of the window?
Because I was locked in, sir, and I didn't have any keys. All windows and everything, all the doors were barred, and this was the only window that was not barred.
So you're saying that you didn't have a key to the front door of the house?
He stole my keys.
No, I support, well, I guess I can't ask for it straight, but you couldn't find the keys after you got out of the basement, fair to say?
I did not see my keys.
Okay, and before you were in the basement, you knew where they were?
Yes.
And there's a fight that happened while you were upstairs, right?
So, so she can't testify. Are you saying while she was in the basement or while she was upstairs?
While she was upstairs.
Oh,
There's
Part of the upstairs, because it's two different parts of upstairs.
on the main floor upstairs.
The main floor, I didn't reside in that part.
Ma'am, if I can pause you, I didn't necessarily ask where you was at. I said, there was a fight that happened on the main floor of the residence, fair to say?
Yes.
Okay, and, prior to that fight, you knew where the keys were located?
Yes.
And then afterwards, after you were in the basement for an hour, you didn't know the keys were located, right?
My keys was not on the main floor.
Okay, and while you're in the basement, you testified earlier that you didn't know what was happening in the main floor upstairs, fair to say?
Repeat the question.
so that's the answer. Move on.
You stated that, Mr. Turner allegedly stole your keys is a guess because you didn't know what happened while you were in the basement, fair to say?
So the testimony about her saying that he stole her keys, that's stricken. There's no direct evidence of that.
Oh, cool. But she just said it, that, okay, as long as that's the court's position.
The testimony is that the keys, she knew where they were when she was upstairs. After she went downstairs, she didn't know where they were. She was unable to exit the house.
Perfect, as long as that's the court's position, I'm good with that. So you jumped out the window and, who's the first person that you contacted after you jumped out of the window?
From you, Lauren.
So you didn't call 911 as the first call we got out of the resident?
My phone was missing.
I didn't ask you that. I said you didn't call 911 as the first call we got out of the basement.
I could not call
Is
911.
that yes or no?
No.
One second, please. Did you have to climb up or anything to get out of the window?
Had to only go up this far through stairs.
I'm sorry, can you speak up a little bit?
I only had to try to get up those, the little stairs in the corridor.
So I'm turning your attention to, like, after you got out of the basement and immediately prior to you jumping out the window. But let me ask you this one, how close is the bottom of the window to the floor?
It's a nice little distance.
Did you have to stand on anything to get out of it?
No,
Do you better say you were able to put your knee on the ceiling to get out?
I would have to, yeah, I would have to put either my knee or put my leg. through.
Okay, which one did you do?
I put my leg, through, with my knee busted up.
Okay, and how did you get from the basement to the kitchen window?
I had to bust the door open, I had to break the door open.
Maybe that was a bad question. Let me ask you a different question. After the door was open for you to get from the basement to the kitchen, how did you physically get from where you were to the kitchen window?
I'm sorry, repeat the question.
After the door was open to the basement, the question is, how did the witness get from where she was, like in the basement, around the basement area, to the kitchen window when she's testifying to?
I had to snatch an oven, so I had to pull the oven out of the way of the window. The oven.
Is it fair to say you had to walk from where you were to the oven?
I had to limp
And
all the
then,
way to there.
and then when you got over to the stove, you had to physically move the stove. Is that what you're saying?
I had to snatch it out, yes, sir.
When you say snatch it out, you want to put it in the wall? Put it away. Okay, so how long did it take the police to arrive once the police were called to the scene? Okay, are we inside or outside the house when the police arrived? I was at the hospital. So the police never came to the actual house to touch you? I was at the hospital when they came to touch me. Okay, so I need to answer my question. So just for clarity, the police never came to the house while you were just at the house to touch you? No. Yeah. So when you initially talked to police at the hospital, did you tell them that you lived out the door? I told them that went to the window and jumped out. All right, so last set of questions, Ms. Brooks. At any point in time, did Mr. Turner live at that residence with you? Repeat the question? At any point in time, did Mr. Turner live at that residence with you? No. Never? Never. Do you remember writing a written statement in this situation, or as it relates to this situation? You recall, do you recall writing a written statement, a handwritten statement as it relates to this situation? So what situation? The situation that we're here for. Yes. Okay, and Sergeant Ball took the statement? You have to say yes or no. Yes. Okay, and did Sergeant Ball ask you if you, and Daniel ever lived together? Yes. Okay, then you answer, you stayed with me for 2 weeks. When you broke up with this old lady, but we never dated, had sex, no kids or nothing like that. He came over there, but I was. So my question is, did you give that response to Sergeant Ball? I believe so, yes. Okay. You say you believe so, yes. Okay. Yes. Yeah. Thank you. So is it true that he lived with you for 2 weeks? No, he did not live there. So you were not telling the truth when you spoke to
I
Sergeant?
was telling the truth.
You have to let me finish the questions that I'm asking before you answer. Okay?
Yes, sir.
Okay, so were you telling the truth when you told Sergeant Ball that he had stayed with you for 2 weeks?
Yes, I was.
Okay, so weren't telling the truth today. You told this court, this judge, that Mr. Turner never lived with you?
He never lived with me. He did come over there a lot for those 2 weeks. He was over there quite a bit.
Okay, one last time, but you told Sergeant Ball that he lived with you for 2 weeks,
I
right?
never said that he lived with me, no.
You stayed.
But he did come over and shower. Yes, he did. If he was not living.
You stayed there for 2 weeks?
He was in and out of the house for 2 weeks.
So would you say that was, did you tell Sergeant Ball that he stayed there for 2 weeks?
I told Sergeant Ball that he was in and out of the house for 2 weeks. He came over and showered and things of that nature. I have no idea what Sergeant Ball wrote. I never seen what he wrote.
Were you given papers in order to write a statement?
Could you speak into the mic? Attorney Sinclair? I can't.
Were you given papers to write a statement, a written statement, a handwritten statement?
Correct.
Okay, and did you write a statement on those papers that you were given?
Yes.
Okay, would you recognize your handwriting if I showed it to you? Or be able to tell me that it's not your handwriting?
Sure.
May I approach the witness, sir? What did I hand you? Or do you recognize what it is that I handed you? Let me expedite.
Form.
Let me expedite this. Is that your handwriting on that paper, the papers that I handed?
No.
Whose handwriting is that, if you know?
It looks like, Sergeant Ball.
Were you given is this the first time that you're seeing those documents?
Yeah.
Okay. Yeah, I first with the shirt. Okay. All right, the last question, did you give Mr. Turner a key to the residence?
He stated that he owned the
Ma'am,
residence.
that's a yes, sir.
Did you give him a key to the house?
I gave him a key to a lock.
And that lock opened what? Lock?
It opened my door
Okay.
to upstairs where the business was.
Yeah.
But that lock was broken.
There are no bars on the doors that led to the exterior of the property, fair to say?
I'm sorry?
There were no bars on the doors that led to the exterior of the property, fair to say?
Could you come over to the mic? Sir?
There were no bars on the doors that led to the exterior of the property. Is that fair to say?
There was bars all over the exterior of the property, sir.
I said the doors that led to the exterior of the property.
I don't know. The doors.
So there are doorways that, doors that if you open them, you're able to get outside, fair to say?
Are you asking?
To the
Hold
front
on,
door?
ma'am, please. Are you asking if there are bars on the doors of the house?
Yes, the doors that led to the exterior of the house. From the inside, doors that lead to the exterior. Were there bars on the door?
So are you asking, are there bars on the inside of the house or are there bars on the outside of the house?
Whatever her answer is, that's. whether it was inside
No,
or
what was
outside.
your question, Mr. Sinclair?
My question was, were there bars on the doors that led to the exterior of the house? So if she answers and says, no, that's fine. If she answers it, yes, that's fine. If she says the bars outside. If she says no,
Right, but we have to know what you're asking.
Okay.
In order to
No.
have the question to you.
no further questions.
Redirect.
Yes, Your Honor. Good afternoon, Your Honor. First, I just have a few clarifying questions. I know, you testified at the previous date and then just now across about the doors in the basement. Just to clarify, the door you couldn't get out of was the kitchen door, correct?
I couldn't get out of the door.
And, the door Mr. Sinclair showed you was the door that you didn't have keys to the bars, correct?
Correct.
And, the other door was a kitchen door?
Kitchen door,
Was that the door you had to break out of?
yes.
While you were downstairs, or let's back up. Were you and Mr. Turner the only ones present at the location?
Yes,
And you didn't see anyone else when you got out of the basement there, did you?
no,
And you knew where your phone and keys were.
I object to the leading question.
Did you have your phone and keys with you?
my aunties were up on the second, on the third floor.
And were they there after you got out of the basement?
They were not.
Nothing for it, but I think you missed what the Are there any other witnesses on behalf of people? No, Your Honor. Are there any witnesses on behalf of the
No, for defense.
Yes. Your Honor, at this time, the people will find over on the information charged as well as an additional count of assault with intent to murder and an additional count of holding firearms. As the court has heard, testimony from this witness of the prior date and this date, there have been several allegations that she, has, talked about, like Mr. Turner. I believe the people have met their word by a probable cause on every count. Going to count one, armed robbery, testimony like Ms. Brooks, who gave that Mr. Turner had a gun with him. She indicated that they were the only two people in the house present at the time this altercation took place. Her keys and her phone were upstairs. She knew where they were, and she got out of the basement after an hour. They were not there anymore. As to count two, unlawful imprisonment, Ms. Brooks was forced into the basement after the altercation with Mr. Turner. After testimony today, there were two doors, however, one door, she did not have her keys. She could not get the bars out, and she had nailed shut. On the other door, she was locked in. Her testimony of the prior date indicated that she had to use a wrench to break down that door, and able to, escape. As count three, Mr. Turner did shoot at her. Additionally, she testified to certain gunshots while she was locked in the basement. As count four, interfering with the crime report, Mr. Turner was the only individual in the house. She took her phone, took her keys. She was locked in the basement. There was no way for her to report the crime. When she got up, she discovered that her keys were there, no longer there. She was not able to keep in her vehicle to go get help. Her phone was taken. She was not allowed to call anyone. She eventually, upon her friend, was not able to call for help. So I believe the woman was working when it comes to that. Mr. Turner's actions were clear. He did not want Ms. Brooks to get out of that house. She did not want Ms. Brooks to call for help. As in count five, assault with intent to great bodily harm, also murder or strangulation. As Ms. Brooks testified the last time she was here, Mr. Turner placed his hand around her neck, lifted her up off the ground, and she testified that she felt directly her body, but she could not breathe. Going towards the assaulted element also, she was meant to land on the ground. He had hit the close fist, and Mr. Turner then grabbed a metal bar so he began hitting her body. At that point, Mr. Turner then left the house after telling her that she was going to die today, and grabbed his gun and then shot at her. Which I think also is enough to mind over on 8 and 7, the felonious assault with the handgun and the felonious assault with the metal bar. Your Honor, we also the count 9 to 14 should be found over. Mr. Turner did have a gun. As to the adding a count of assault and murder, I think Mr. Turner's actions here. You don't just say you're going to kill someone and then shoot at them and assault them to the degree that Ms. Brooks was assaulted without actually intending to kill someone. He locked her in the basement and continued shooting. And she testified to her injury. She had a broken bone in her occipital, severe bruising all over her body, which took her 8 to 10 weeks to recover from. She was on crutches. And she had a hard time getting out of the house, because of her injury. Or I believe, one other burden, the out of town is all.
I object to the bind over. I object to the bind over on the charges as stated in the complaint warrant, and I object to the bind over on the charges that Madam Prosecutor wishes to add. In Madam Prosecutor's bind over argument, she makes statements that are not supported by the record, and I'm sure the court is able to distinguish between the testimony properly admitted in the record and the theory as to why certain charges should be bound over or not. One example of that is there's no testimony in the record that Mr. Turner ever shot at Ms. Brooks. That's no, she didn't testify to that. It's not in the record. That's just one example. To count one, that's the armed robbery charge. There's no foundation in this record to sustain that charge. Ms. Brooks, you testified, over and over again today, and at the I'll call it part A of the preliminary examination, that she was in the basement for between 40 minutes to an hour, and she doesn't know what happened while she was upstairs, while she was in the basement. She doesn't know who came and went. She doesn't know who else was up there. She also testified that she had that I may have the person's swap, but the information was she has a family member that was her was an alcoholic and one that was a crackhead, and that was the reason that she kept certain entrances wired in the house. And there's nothing in this record to show that her inability to find her keys or her inability to find her phone should be attributed to Mr. Turner and not be any other person that was present or came and went from the house while she was not able to, while she was in the basement, while she wasn't able to see the activity coming in and or out of the house. The fact she didn't know what they were doesn't mean that that they were stolen, that they were taken, and she wasn't present. So that's one of the requirements of armed robbery charge. Fear and person present. She was in the basement, and she can't testify to activity that happened somewhere else where she wasn't present. Count 2 is an unlawful imprisonment charge. I'm asking for not to mind on that. One reason is because we have a credibility issue with this witness. At first, she was saying that she held the door shut, and that's why she couldn't get out. And then she came up with testimony that there was a lock on the door that she didn't have a key to, and that was actually the reason that she wasn't able to get out of the location. I showed her pictures of the door. She was saying, where the holes were allegedly located. Where the nails were previously located, when she said that one. And then on the picture, there was no lock that required a key to exit the door. It was a kind that you open from the inside, one of those twist turn locks, and no indication that there was a lock that required a key to open the door, or anything of that nature. I'm going to jump down to count 4, the interfering with the crime report, and that, in my view, connects to count 1, that she's accusing Mr. Turner of causing her interfering with her ability to call the police and things of that nature. 1, she doesn't have a foundation for that testimony. And number 2, when she got out of the house, she had a device or whatever she used, and she didn't call the police. She called a friend. So Mr. Turner shouldn't be charged with interfering with the crime report when it was clear that her intention wasn't to call the police, because when she had an opportunity to do that, she did. She called a friend. Yeah, and I'm just asking for not to mind other charges without arguing. For her testimony, for example, the assessment of credibility as relates to that testimony, differences between the testimony that made it to the record and theory.
Thank you. Ms. Wolf.
Just briefly going to the door issue, Ms. Brooks always had to find the door to not get out of the door that she was locked in from the kitchen. Regarding the other door, she did testify that she nailed the door shut. As you saw in the picture, there are 2 doors, the interior one and the exterior. The exterior one has the bar. She testified to saying that you cannot get out without the key, and she did not have the key. So what Mr. Sinclair tried to allege there, I not entirely what Mr. Brooks testified to. As he interfered with the crime report and providing her testimony of calling her friend, I don't believe her testimony was that she called her friend of she I had Wi-Fi to get in touch with her friend. She would not have been able to call 911 from that
Please
iPad.
don't talk while she's talking.
So and then going back to, her testimony, Mr. Turner was the only individual there in that location, when the altercation began. There was no one there in the house when Ms. Brooks finally broke out of the basement. Based on those facts, alone, I believe Mr. Turner was the only person there present, and seeing that her keys were gone and her were gone, there's only a lot of conclusion that Mr. Turner, in fact, did take those items from her. So Your Honor, I would still be asking to find over on the information as far as well as the additional counsel.
Thank you. The court heard the testimony from Ms. Chantel Brooks back on February 16th, and her testimony concluded today regarding the incident that occurred on September 26th, 2020, at her place of residence, which was located at 14656 Buffalo Street in Sydney. To identify Mr. Turner as someone she was familiar with. Mr. Turner is charged in count 1 with robbery and harm. Court is not satisfied that the people met the burden of proof by probable cause and establishing that there was in fact larceny of keys and phones used by force from Ms. Brooks on the date in question. And the accompanying felony firearm charge in count 8 will be dismissed because of that. In count 2, unlawful imprisonment, the court is satisfied that the people met the burden of proof by probable cause standard, ensuring that Ms. Brooks was in fact restrained from leaving her home on the date in question, and there was a weapon that was used to secure her confinement in the basement of her home on the date in question. So the court is satisfied that count 2, as well as the accompanying felony firearm count, has been satisfied by a probable cause standard. In count 3, weapons, firearms, discharge in a building, the court is satisfied that the people met the burden of proof by a probable cause standard, showing that Mr. Turner did intentionally discharge a firearm in the home, and he knew that Ms. Brooks was in the home at the time that he fired that. In count 4, interfering. So the court is further satisfied in count 11, felony firearm count, that has been satisfied. In count 4, interfering with crime report, committing crime, threatening to kill or injure. The court is additionally satisfied that the people have met the burden of proof by a probable cause standard, showing that there was some means of removing Ms. Brooks' phone, precluding her, preventing her from calling the police at the time that this incident occurred. So I am satisfied that that has been established by probable cause standard, in addition to count 12, the felony firearm count. In count 5, self-intended great bodily harm, the court is satisfied that the prosecution is immense burden in showing that Ms. Brooks was assaulted and there was some intent to do great bodily harm less than her. The way that she described she was beaten by the defendant, I think, satisfies that requirement, as well as the felony firearm count that is associated with it. Count 6, larceny in building. The court, based on Ms. Brooks' testimony, is satisfied that so in count 5, intent to do great bodily harm less than murder, doesn't look like there is a firearm count that is associated with that. That's for the beating with the bar stool and the beating that Ms. Brooks had as a result of Mr. Turner's actions. So that count has been satisfied. Count 6, larceny in building, the court is satisfied that the people left by probable cause standard, and that she testified that her phone was in her house when she was there. Her phone and the keys to her car were in her house. And when she went to leave, when she attempted to leave the house after no one else was there, and the only person that she knew to be there was Mr. Turner, that phone and that those keys were no longer there. So the court is satisfied that there has been showing by probable cause standard as it relates to that count and the felony firearm count that is associated with it. In count 7, assault with a dangerous weapon, the court is satisfied that the people method were improved by probable cause standard with that and the felony firearms count that is associated with it. And as it relates to the prosecution's motion to amend the information to add a count of assault with intent to murder and felony firearm, the court believes, based on what it heard from Ms. Brooks regarding the beating that she sustained, the weapons that were used, the court is satisfied that the people's method were improved in establishing that there was, in fact, enough evidence to show that there was an intent to kill her in the day in question, and the firearm count associated with it. So, Mr. Turner will be bound over on counts 2, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, and an additional counts 15 and 16. Counts 1 and 8 are dismissed. We'll be arraigned 2 weeks from today, which is the 20th of May at 9 a.m.
I've been in contact with Ms. Brooks. She had alleged that customers were contacted with individuals to reach out to her about this case. The defendant has also gone up to her mother's house to try to discuss this case. Part of the reason why she doesn't reside here in Michigan is because of the instances that have happened. She's afraid for her home with her mother. As the court has heard the testimony and the assault that Brooks has suffered, people would request that bond be increased.
Let me ask you this. When we were last here on February 16th, are you alleging that there's been, I know that you stated that there was some contact around that time. Are you alleging that since February 16th, Ms. Brooks has continued to receive third-party communication and that Mr. Turner has been to her mother's house since we were last here in court?
Yes, I believe so, because I was not aware of that before the 16th. I definitely am aware of that.
All right. So, okay. Can you bring Ms. Brooks in? Ms. Brooks, if you can come up to the microphone at the podium. All right, and you remain under oath, yes, ma'am. Okay, so since we were last here in February, have you received phone calls referencing this case law?
I have received a call from Nick Turner the day of court that I did not answer. And I've received a third-party call from someone, no, can't remember his name, but we call him Smoke.
When did you receive the call from this month?
19 weeks ago.
And what was the nature of the communication between you?
I did not answer.
Okay, all right, so then you said that you received a call from Mr. Turner on February 16th, is that what you're saying?
The day we were in, yeah.
Okay, all right, and you know that he called you because You had this phone number programmed in your phone?
Correct.
Okay. Did you answer that call?
No,
All right. Did you, was there a message left?
no.
All right. Next, ma'am, has there been any communication between Mr. Turner and any members of your family?
He spoke with my mom.
Okay, when did that occur?
That occurred, I'm not sure what day he spoke with my mom.
All right, so,
If she's testified.
all right, can you tell me when, what month it was that that Mr. Turner spoke with your mother? Was it before we were last here?
Before we last name.
Okay, so it has not been since February 16th, definitely.
Not that I know.
Okay,
I haven't been able to, reach out. My mom's birthday was just that. I'm nervous.
all right. You talked to your mother, right?
I haven't been.
All right, thank you.
Yes.
All right, thank you. So the court has had an opportunity to consider the motion of the prosecution in increasing Mr. Turner's bond. Based on the testimony that the court has heard from Ms. Brooks, the communication that has occurred with her happened before we were here last February 16th. The court understands that there was someone that she and the defendant are familiar with called her, but there's nothing more than her having received a phone call from that individual. So the court is going to deny the prosecution's motion to increase the bond at this time based on what the court has just indicated, and that this Brooks, this occurred a couple years ago, and Ms. Brooks is no longer in the home located at Cloverdale and in the area at all. The court will remind Mr. Turner that you are to have absolutely no contact whatsoever with Ms. Brooks, with her mother, with her family at all, and you are to not have anyone that you all are familiar with together contact. Do you understand that, sir?
Yes, Your Honor.
Okay, don't say nothing more. You understand?
Yes, Your Honor.
All right. Is there anything further?
Your Honor, I don't know if Mr. Turner is on other, but the people would request that we consider other. Given the serious nature of the allegations that you heard today.
There's no need for it, because there hasn't been any bond violations, been on bond for about roughly a year or so. There hasn't been any bond violation. He showed up to every court proceeding that has been scheduled for, and to be on bond that long, there's been tons of court proceedings and tons of court dates. He's always showed up, kept in constant communication with me, him and his fiance, his father, everybody has kept in contact with him. He hasn't failed to appear, or anything that I retain counsel is committed to see this. So there's no need to essentially increase bond, because the court actually already ruled on the motion to increase bond. And added tether was no tether is another motion to increase bond. So that's what it's not precedent.
This is what you have some additional add.
Your Honor, just as to the alleged contract.
Yeah, just hold on.
Sorry, I apologize.
All right, so I'm not gonna add the tether, because it's been 2 years and she's not here, and there's nothing more. I mean, I don't want anything to happen, but I'm not gonna add a tether. Thank you, dispatch.
Thank you. Have a good sir. You step out, sir. I'm going to. All right, have a good day, sir. All right, have a good day, everybody. All right. Have a good day, Judge.
Thank you, Judge. Have a good day.
Bye, Mr. Anderson. Is this your case, Wes? I'm
sorry.
hearing Mr. Hall.
It will be handled.
Okay.
Thank you, Judge.
You ready, Ms. Franklin?
I am, Your Honor. Thank you.
This is the people of the state of Michigan versus the Charles West. Case number 22-F56-831. Mr. West is charged in count one, jails, possession of weapon. And your appearances, please.
Good afternoon, Your Honor. Alexander on behalf of 84516. And good afternoon, Your Honor. Attorney Gianna Franulik, P73015 on behalf of Mr. Charles West. Both present. Mr. West to my left behind me. Please state your name for the record. Speak up, please.
Charles West.
Thank you.
Thank you. Good afternoon. Today is the date and time set for preliminary examination of the parties to proceed.
Yes, Your Honor. And Your Honor, at this time, I have had an opportunity to speak with Mr. West regarding the discovery. Confirm I did receive it yesterday and review it, advised him regarding probable cause and testimony as well as the burden, whether or not he probably committed the crime and if he probably committed in the city of Detroit. In doing so, advising him of those facts as well as how they could possibly relate to his other outstanding matters. He has indicated he wishes to waive his exam and have this matter bound over to circuit court, hopefully with global resolution.
Mr. West is what the lawyer stated, correct? Yes. Sir, as your lawyer explained to you, you have a statutory right to have a preliminary examination. At a preliminary examination, the prosecutor will call witnesses and would have to show by the probable cause statement that you committed this crime that you're accusing of and that the crime occurred in the scene. You understand that? Yes. If you're choosing to not have your exam held here today, but to have your case move forward to the circuit court for further proceedings. Yes. Has anyone forced, threatened, or promised you anything to get you away the right to proceed? Any objections?
No, Your Honor.
Court will accept your waiver. You'll be bound over to the third circuit court for arraignment on the information. Your arraignment will occur 1 week from today, May 13th at 9 a.m. Ms. Franulik and Mr. West, either of you have a problem with the court signing the waiver form on your behalf?
No, Your Honor.
So then May 13th is the next day.
Thank you. I'll have to. Okay.